Second case on this evening's docket. That is case number 109864, Willis L. Armstrong and Stephanie Prohaska, appellants, versus Bromley Quarry and Asphalt Incorporated, appellees. Counsel, for the benefit of the audience, after you state your appearance, if you could give us a factual recitation so the audience knows what kind of a case we're talking about.
May it please the Court, Pat Miller on behalf of Bromley Quarry and Asphalt and Barbara Bromley. May I reserve 5 minutes for rebuttal, Your Honor?
5 minutes is granted.
Thank you, Judge. Your Honors of the Court, this case involved claims of trespass and conversion. My clients were the owners and operators of a rock quarry and asphalt manufacturing plant located in Atchison, Kansas. My client Barbara Bromley began operating the quarry and plant in the 1980s after her husband tragically died of a heart attack. Barbara was a stay-at-home mom and learned how to operate the mine and the asphalt company, and then over the years encountered her neighbors, the Armstrongs. John Bromley had previously entered into a lease agreement with the Armstrong family, and that lease agreement went well for a number of years. Later, when Barbara Bromley was managing the rock quarry, litigation began. The parties began to dispute the terms of the lease agreement, and they ended up in court a number of times. Suits were filed in '92 by the Armstrongs, again in '96. Those lawsuits ultimately were resolved back in '92 and '96, and the parties seemed to coexist peacefully. Yet the Armstrongs always believed, as they testified in deposition and at trial, that the Armstrong property was being undermined by the Bromley quarry. At some point, moving forward into 2011, the Armstrongs began speaking with a gentleman by the name of Gary Service. He was another mine operator in the area, a competitor with the Bromley mine. And Mr. Service wanted to enter into a lease agreement with the Armstrong family to begin mining from their property. As they were engaged in those discussions, Mr. Service entered into the Bromley mine. He entered into there was a main entrance, and then there was an emergency escape entrance that apparently all mines need to have, and it was also there for purposes of ventilation. But Mr. Service went into the mine and walked through the mine and noticed that there was rock missing where he believed the rock ought to be, and reported that back to the Armstrong family. And they, in turn, went into the mine themselves and inspected the mine, and ultimately brought suit against my clients, Barbara Bromley and the Bromley Quarry and Asphalt Company, seeking damages for trespass and for conversion. The case went to trial. It was tried to the court. Judge Bednar in Atchison County heard the case, issued findings of fact and rulings. He did find in favor of the Armstrong family. He made a determination that 173,392 tons of rock had been mined from the Armstrong family in the 2 years prior to suit being filed. Judge Bednar determined that the 2-year statute of limitations should apply to all claims asserted on behalf of the Armstrong family. Judge Bednar then determined that the recovery would be roughly, well, ultimately he determined that the Bromley mine had acted in good faith. They were deemed a good faith trespasser. They had trespassed, but they didn't intend to take the rock. They didn't intend to steal the rock. That they were, but it was an innocent mistake, as he indicated in his findings of fact. And so, based upon that determination, he determined that the defendants in the case were good faith trespassers and assessed damages of $1 per ton. And that measure of damage was based upon the net profits that were obtained by the Bromley mine from the Armstrong rock. So that number was then reduced based upon the fact that we only had 75% of the ownership group of the Armstrong family participating in the suit. So that reduced the damage award, as well as a 10% reduction of the award for the amount of rock that was deemed waste. And so that ultimately led us to a recovery on behalf of the Armstrong family of $117,039.60 on the trespass and conversion claims. Judge Bednar awarded an additional $10,000 in nominal damages based upon my client's use of the Armstrong property, where they had moved a haul road that went onto the Armstrong property. Of course, everything we're talking about is going on underground, but there had been a haul road that had been moved to traverse across the Armstrong property just a couple years prior to the suit being filed. That was done because the road that had been used for a number of years was in bad shape. It was going to cost a substantial amount of money to get that road back in working order, and the Bromley Quarry folks had spoken with state and federal regulators who had given their approval for the move of the haul road, and so based upon that approval, they had the understanding that they were allowed to do so.
Can I clarify, in
Yes.
the 1996
Yes, Your
court
Honor.
action, I understood that the court denied the Armstrongs' request for access to the mine, correct?
Yes, Your Honor. There have been.
That's the answer to that's yes.
Yes.
Because then I want to continue on, and in connection with that, the judge ordered that your client was not to trespass upon or mine minerals from the Armstrong's land. Is that correct?
Yes, Your Honor. That
So
is
your
correct.
client was under a court order not to mine on the adjoining property, and at that point, the zero aisle, which you call the haul road, was established, correct?
That's not correct, Your Honor.
Okay.
The zero aisle and that haul road was not established until William Falk became the superintendent of the mine, and that was sometime in about 2003, is my understanding.
And when that was established, that was believed to be the line beyond which your client could not mine limestone. Is that correct?
It was the direction of Barbara Bromley to Mr. Falk and other superintendents and employees of the mine to stay off the Armstrong property. So what Mr. Falk did, not being an expert, being someone who started out just driving a truck in the mine and mowing the grass above the mine, he did his best to use a compass.
Well, let's go back. You said that regulators told you could go on and move the haul road. When the haul road was moved, it was moved on the Armstrong property, correct?
That's correct.
And at that time, your client was under a court order not to do that.
From
Is that correct?
1996, that is correct, Your Honor.
Okay. I just wanted to clarify that part.
Yeah, and that's true. And Judge Bednar did award damages of $10,000 based upon the use of that haul road.
Counsel, I want to move you over to one of the issues in this case is when the statute of limitations would begin to run, when the claim would have accrued. And in part of that discussion, it's whether the plaintiff, the Armstrongs, could reasonably ascertain that there was a trespass occurring, okay?
Yes.
And part of the court's analysis was looking at, and the arguments that you made referenced mining statutes, 49-101, but then there's also a reference to 109. And are you familiar with the two statutes that I'm talking about? I'm trying to figure out, because you've referenced 109 in your brief. The district court talked about 101. And when I look at those two statutes, I think they read differently. And I'm trying to figure out which one I'm supposed to look at.
Well, maybe this will help. I wish I could be more specific about it. I was looking through those briefs just before our arguments here today, and I have it down as 49-106.
Well, and maybe I misspoke, but
Yeah.
let me see here.
Which I believe is the
49-106.
Yeah, and I didn't, and I'll admit, Your Honor, I did not pull the statute and review it. I reviewed my brief, and I reviewed the court's order, or the court's memorandum decision. I believe it was 49-106, which states that upon filing an affidavit with the district court, the plaintiffs could have been provided an opportunity for an inspection of the property. And I believe the other statute states that they also could have sought a TRO, a temporary restraining order, if they were to determine that there had been mining on the property.
But it takes more than a suspicion, does it not? If I recall the statute, it says first you have to submit an affidavit.
Right.
And you have to swear to that affidavit.
Yes.
And that affidavit has to say that the affiant has good reason to believe there was an encroachment upon their property.
Right.
And so it's not just a fishing expedition. And so the Armstrongs would have had to have more than a suspicion, would they not, to file a candor to the tribunal affidavit?
Well, I think based upon their testimony and deposition at trial, they had more than a suspicion. They talked about blasting that was occurring in the 3 to 5 years before they brought suit that was so severe that it shook dishes off their shelves. They talked about consistently having a suspicion throughout that they were being undermined, but they actually had the evidence they could have presented that they had substantial explosions going on. And mind you, Your Honors, they went on in. I mean, if you ask them, their testimony was they were entitled to go in that property. They didn't trespass on the Bromley property because they entered into a hole in that mine that was located on an adjacent landowner's property. They had gotten that person's permission, walked right on in there and inspected the property and made a determination that this trespass and conversion had occurred.
Is that when the claim accrued?
No, the claim would have accrued when the rock was taken.
Okay, so what difference does it make that they went into the mine then?
Well,
Doesn't
it makes
that beg the question of when was it reasonably ascertainable?
I think it makes a difference because they're hearing explosions, they're feeling explosions. They've got this long-standing suspicion that's gone on for a number of years.
So they know a mine is next door, so they hear explosions.
They know a mine's literally beneath them is essentially what they testified to.
Well, did they testify to that?
Well, they testified that the explosions were so severe would shake the dishes off the shelves.
Okay, so they've got explosions shaking the dishes. They've also got a court order that they know exists that tells their neighbor, you can't trespass on this land and you can't mine their rock, right?
Right.
What beyond that? This is all happening underground, right?
Right.
They're barred from entering the mine to inspect on their own. I guess my question is, what do these statutes have to do with whether or not this was reasonably ascertainable at all?
Well, I guess I would certainly not argue with the court, but point out that in the plaintiff's mind, they did have a right to enter the mine because they ultimately did. They did have a right to enter the mine.
But you're not arguing that the claim accrued when they entered the mine.
No, that's correct. As the law would state on a conversion, it occurs at the time the items are taken.
My reading of the Court of Appeals opinion, correct me if I'm wrong, is that the court affirmed the district court on the grounds that the trespass was reasonably ascertainable because Armstrong could have surveyed the property pursuant to these statutes. That's the essence of the Court of Appeals ruling, correct?
Correct.
That's my question that I put to you. Why does a plaintiff or an injured party in this circumstance have to go through the effort to have the property surveyed? In other words, reasonably ascertainable to me doesn't mean could be discovered if we know where to look. I analogize to a medical malpractice case. You know, you've got the clamp left inside you. There's no symptoms necessarily, but if the person has an MRI or a CAT scan, it would be discovered. Do they have a duty to do that under the reasonably ascertainable standard?
I think what the standard states is that they have a reason to investigate. When they have reason to believe that rock is being mined from their property, they have an obligation at that point to investigate, and if they don't, they risk waiving their claim.
And the only evidence that you're relying on here that they had a reason to investigate is the blasting.
The blasting and the plaintiff's own testimony that they always suspected, and that the plaintiffs routinely went to the Kansas Geological Survey attempting to get maps.
Which goes to my question. Didn't they do some investigation?
They did.
By going and getting those maps, and didn't those maps continuously show them that there was no mining on their property?
The maps were inaccurate, and there's no disputing that. And there's an explanation why.
But why is that not an investigation that would have lulled them into believing that they were not injured?
Well, those maps weren't provided to the plaintiffs.
Is there any necessity for that?
I think in order for my clients to be penalized through an extension of the statute of limitations based upon their conduct, there should be some consideration that they either know or intend that they're engaged in conduct to lull the plaintiffs, and that isn't what was happening here.
I don't understand the Armstrongs to be alleging that there was fraud that hid the running of the statute of limitations. I read their argument more, and counsel can correct me, but that we did take steps to do an investigation. And the investigation we did made it so that it was not reasonably ascertainable that we had been injured.
I think it's an objective standard, from what I understand in reading the law. And my recollection of the evidence at trial and at the stage of summary judgment was that the plaintiffs were alleging that my clients engaged in fraud, that they did intend to misrepresent intentionally their progress to those
but at
matters.
our stage, I don't believe we have any factual findings that would allow us to rely on fraud. Is that correct?
I don't think there's any evidence of fraud.
So at our stage, if anything, it would be more this matter that I was mentioning, that they did take steps, and the question of whether that, from an objective standard, was a sufficient investigation to mean that the damage was not reasonably ascertainable.
I think the lower court, both the trial court and the Court of Appeals, both determined that these claims were reasonably ascertainable. Had the plaintiffs made the decision to inspect the mine, as they eventually did earlier, had they sought to involve the district court through submitting an affidavit under 49106, or the other thing that we haven't discussed yet, it's seeking an inspection through the Kansas Department of Health and Environment through their regulations, which could have been done even anonymously.
You indicated that you thought it was an objective standard. Are you basing that on Dexter?
I think any obligation to ascertain a claim, if we're going to look at it in terms of, well, they tried and they just couldn't find it, what we run the risk is extending out just about any claim. I mean, potentially just abrogating the statute of limitations. If a plaintiff can simply say, well, I thought someone had stolen something from me And I asked them, "Did you steal from me?" Is that enough? I mean, I think you actually need to go and take a look.
And if it is an objective standard, what is our standard of review?
Well, I think in this case, with the trial court, I would expect it would be an abuse of discretion. Did the court appropriately apply the law? Were there sufficient facts to support the court's findings?
Thank you, counsel. I think we understand your position. You're about 10 minutes over your allotted time. We'll see you on rebuttal. Thank you.
Thank you, Judge.
Counsel, I want to move you to what we've been talking about reasonably ascertainable. And one of the things that you got hit with from the Court of Appeals was the statutory right of your clients to be able to get a court ordered for a survey. And that's those two statutes we talked about, 49-101 and 49-106. My problem is that it looks to me like those statutes set up different standards. One talks about that the person asking for the survey has to have a good reason to believe, and the other one, 106, just says stating from knowledge, information, or belief that there's been a drifting over the property. Do you think that either one of those two statutes are relevant when we start trying to figure out whether your clients could have reasonably ascertained that there was underground mining going on?
I don't believe so, Your Honor, for a couple of reasons. First of all, and if I can maybe step back from your question just to provide a little background, everyone is focused in this case on essentially the first of the two Davidson prongs, which is analyzing at what point does one have to investigate to ascertain whether there was reasonable ascertainable evidence of an underlying illegal act. Everyone is ignoring the second prong, or actually before we even get to the second prong, before an individual has a duty to investigate, there has to be more than a mere suspicion that there is illegal activity. The case law in Kansas is quite clear. There has to be actual knowledge before that duty is even triggered to investigate. And let's say, for instance, that would then take, let's say that there was actual knowledge. If there was actual knowledge, then there would be a duty to investigate. And then you get to the question as to whether or not the plaintiff's efforts to investigate were sufficient, and whether it was reasonably ascertainable that there was a taking going on below their property. But again, before you even get there, you have to get beyond that requirement. To trigger that responsibility, that obligation, there has to be more than a mere suspicion. There has to be actual knowledge. The second prong of the Davidson analysis is that, I'm losing track of myself here. The second prong of that analysis goes beyond whether or not there was a duty to even investigate. The second prong of that analysis goes to whether there were any attempts to conceal or misrepresent the illegal activity that was going on that would have produced a suspicion of illegal activity. So first of all, we have to decide, was there a duty to investigate? We would argue that there was not, that there was never anything more than a mere suspicion that mining activity was going on. But even though there was no duty to investigate, my clients did a number of things. The first thing that they did is they went to the First Judicial District Court of Atchison County, Kansas, and they sought, through counsel, to gain access to the mine to ascertain whether, in fact, there was a taking. Now, defendants had argued that my client's attorneys at the time essentially mishandled the case, that there were available to them the two statutes that you referenced, that under those two statutes, it's argued by defendants that either of those might have been able to gain access to the mine. My client's prior counsel, unfortunately, didn't attempt to obtain access to the mine using those two statutes. Instead, what they did is they sought a temporary injunction, and ultimately their efforts to gain access to the mine were denied. My clients are lay people, Your Honors. They would have no idea whether or not their attorneys were taking advantage of the instruments that were available to them to gain access to the mine. All they knew was that they had a suspicion that there was mining. The first thing that they did was they went to counsel to try to gain access to the mine. The court denied them access to the mine, although, as it was revealed earlier, the court did order that defendants were not to trespass upon or mine on my client's property. After being denied access to the mine, did my clients then just stop? No, they didn't. What did they do in addition to that? Well, the first thing they did is they found out whether or not there was any reporting going on that would give them an indication as to what the status of the mine was. And what they learned was the defendants were required to report both to the Kansas Geological Survey and to the federal government in the Agency of the Mine Health and Safety, MSHA as we call it, is required to file on an annual basis mine maps that show the activity in the mine and the progression of the mining within the mine. Well, they did that as well. And year after year after year, they checked to see whether there appeared to be any activity on their property. And year after year after year, the defendants showed the activity that was going on to the north of my client's property, but failed to show the rock that was being removed from my client's property. At any rate, in the course of their investigation, now they've tried to counsel. That didn't work. They've gone to take a look at the mine maps. Based upon those mine maps, they believed that there was no reason to believe that there was any ongoing mining under their property. In addition to that, they talked to, there was some evidence in the depositions and reference in testimony at trial, that they also looked at getting seismic analyses. They were told that seismic analyses wouldn't do them any good because there'd be no way of telling whether the mining activity is going on under their property or under the property immediately adjacent to it. They ascertained whether there was a possibility to get core samples and found out that the expense of core samples was tremendous, and there was no guarantee that that would work either, because if the core samples were drilled where there was a pillar in the mine, in other words, where there was solid rock, you could drill core sample after core sample after core sample and never ascertain that there was any missing rock if you're drilling into those pillars. So based upon expense and the fact that there was no way to ascertain for certain through a core sample whether there's mining going on, they rejected that. Ultimately, in 2011, they approached, as was referenced in Mr. Miller's address to you folks, they approached a third-party mining operation and proposed that they begin mining my client's property from the east and slowly work their way towards the west, where ultimately those mining efforts would join in the previously excavated mine. And at least at that point, years in the future, they would have access to their own mine. And I would note that that hasn't even yet happened. There's been mining in conformance with that contract and lease now for several years since this was filed in 2011, and they still haven't gotten far enough over to join up with the old mine. But the bottom line here is that there was no duty to investigate because all it had was a mere suspicion. They investigated anyway, and at every turn, the answers that their investigation revealed to them is that they could not prove that there was any mining activity going on. And the second prong of the Davidson analysis, part of their investigation was to ascertain through viewing the mine maps filed with the state and federal government whether there was activity going on in the mine, and defendants were misrepresenting the activity that was occurring on the property. Every single one of those mine maps showed no activity whatsoever as occurring on my client's property. Now, the defendants have argued their sole basis for their argument that there was readily ascertainable, or that my client knew that there was mining going on under their property, their sole basis for that argument is that my client heard the shaking of windows, rattling, was able to feel vibration, hear the sound of blasting. But if you look at the trial transcript, at no time, at absolutely no time, did the defendants put on any testimony whatsoever, none, that would indicate that vibration and sound that my client was hearing could not be attributable to the mining that was known to be going on to the north of their property. In other words, there was no way to know what she was feeling and hearing. There was no way to know whether that was going on my client's property or whether it was going on to the north of my client's property, which was actively being mined. And the analogy that I would use is that essentially what you have, if you look at the maps, is you have a large area, a large open area under both my client's property, the property to the north, and the property to the west. And what essentially happens here is analogous to the sound chamber in an acoustic guitar. sound is transferred and amplified by virtue of the fact that you have that big hollow, and there's no way to know whether the blasting that you were hearing and feeling is on the contiguous or adjacent property or whether it's on your own. And we feel that it would have been defendant's burden to prove that this one and only reason why my clients would have suspicions, they needed to put on some sort of evidence from which the trial court then could have formed the conclusion that the blasting that was being heard was likely to have been on my client's property. But there is no such evidence.
It's their burden in your view because they're asserting statute of limitations as a defense?
It is, they argued that the fact that mining was going on was reasonably ascertainable, and they argued that my clients had a duty to ascertain whether there was mining going on their property on the basis of hearing the sounds of blasting and feeling vibrations. What I'm saying is that there should have been a connection between this feeling of vibrations and hearing of sound. There should have been a connection made between that and the conclusion that the trial court made that that blasting, that those vibrations and sound must have had something to do with activity going on my client's property.
But I think the chief is asking you about the burden. That burden rests on the defendant because it's asserting the affirmative defense of the statute of limitations. That's your position?
That would be my position, yes. That would be exactly my position.
Okay.
Can I carry you on with
Please.
that burden? It appears that you're making the alternative argument that the statute of limitations never began because it was a continuing trespass, but that argument first appears at the Court of Appeals?
No, Your Honor. The argument of a continuing trespass was made early on in the process in response to the defendant's motion for summary judgment. It was never adequately addressed by the trial court, and it was never addressed. It was referenced by the Court of Appeals, but it was never addressed by the Court of Appeals. And that laid out yet another basis upon which my clients should be able to successfully go back beyond the statute of limitations to the statute of repose. Essentially,
well, let me get you back to my question.
Okay, please.
If we determine the record doesn't support that was adequately raised in the trial court, is that still part of the defendant's burden because the statute of limitations is an affirmative defense? The defense has to raise it and has a burden to carry it. Would they have to also show that it was not a continuing trespass in order to show when the statute of limitations began to support their affirmative defense, or do you have to come forward with that evidence?
Your Honor, I believe that they would have to come forward with that to support their defense.
And so can we at this point say that because the trial court did not make findings about that it's over and the defendants lose on that point, or do we have to remand for more factual findings?
Your Honor, could you state that, please?
As I understand it, the trial court didn't make a finding that there was a continuous trespass.
Correct.
So as we sit here, we don't have a finding to say that that we could apply that. But so what I'm trying to figure out is, are you saying that because the defendant didn't make the effort to assure that the trial court did not make that finding, that the defendant is now lost on that issue? Or is it just that the issue's been raised and we remand it for the findings to be made?
I think it would be unfair for me to argue that it shouldn't be subject to remand, but quite frankly, in the context of the rest of the issues which face the court and that interplay into whether a remand is appropriate, I don't think that a remand ultimately is necessary. I don't think that we have to rely exclusively on the continuing trespass, if you will, to overcome what we believe was the appellate court's error when it didn't allow us to invoke the statute of repose. The continuing trespass is merely another legal theory under which we believe there was error in this case, and the Court of Appeals didn't address it. The Court of Appeals noted that the argument was made, but the Court of Appeals didn't actually address it. Our problem with the Court of Appeals in terms of what they did address, and what we believe was inappropriately decided, brings us back to whether there was a duty to investigate and whether there was actual knowledge or whether there was a mere suspicion which would have triggered a duty to investigate. I hope that that answered your question. In addition to that, I guess what I'm saying is that we believe the continuous trespass essentially would keep the statute of limitations from even beginning to accrue until the discovery in 2011. If we were to succeed on the argument that there was a continuous trespass, we should be able to recover for the amount of rock that was removed, the whole 550,000 tons of rock that was removed all the way back, regardless of how early it occurred. We know that in 1999, the defendant stipulated that no rock that was not shown as having been removed in the 1992 survey, that no additional rock had been taken. If the statute of limitations doesn't actually accrue until the end of the continuous trespass, theoretically, we could go back even farther than the 2-year statute of limitations, even farther than the 10-year statute of repose, theoretically. But again, the continuous trespass is just one of the bases for which we believe we have the ability to go back and recover for all of the rock that was removed, rather than just the rock that they admitted to removing the last 2 years, which was the 173,000 tons, as opposed to the 550,000 tons.
The statute of repose doesn't get you back to 1999, does it?
Statute of repose would take us back 10 years, plus the 2-year statute of limitations, yes.
Counsel, you're out of time, but one question that might be of benefit to all of us. You're talking about so many tons of rock being removed. Using this auditorium cubic feet as an example, how many auditoriums are we talking about?
Your Honor, my clients own a quarter section of property. If you look at the maps, I think that you could say that about a third of that quarter section of rock was removed. I would only be estimating, but we're probably talking 100 of these auditoriums.
Very well. Thank you, counsel. Do we have any more questions?
I want to I know we're out of time, but I want to circle back on what you're asking us to do. Do you really want us to remand this case back to the trial court to basically have another trial on the amount of damages going back for 10 years or whatever the number is going to be?
Your Honor, we're asking for two things. One is that we are asking that you affirm the appellate court's ruling that the appropriate damage per ton is $10 a ton based upon its fair market value or its enhanced value. That isn't an issue that I've even had an opportunity to address, but I think it's been very well briefed. That's number one, what we're asking. In other words, we believe for that 173,000 tons of rock that my clients, before adjustment, should be due $1,730,000. Secondly, we're asking to remand the case back to the district court in order to allow us to admit the mind maps that the trial court rejected, which would have allowed us to establish that a total of 550,000 tons of rock was actually taken from my client's property. So I guess what I'm asking is that we would like to be in a position in which we are secure in the $10 a ton damages for that which it has been stipulated by the defendants that they removed to the tune of $1,700,000. But we also believe, either through the operation of the statute of repose or through the continuous trespass, that we have an opportunity to go further back and recover from more of the rock that was lost in this case. Does that answer your question, Your Honor?
Yes, thank you.
In your argument for the bad faith trespass type of damages is that Brumley clearly knew that they were extracting rock from your client's property.
Actually, no, Your Honor. I believe that it is clear that the defendants knew that they were extracting rock from their property. But the good faith, bad faith distinction is clearly a matter of law. It's not even driven by the facts. Based upon the facts in this case, whether they were favorable to my client as recited by the trial court, or whether they were favorable to my client as recited by the Court of Appeals, really makes no difference, because the distinction between good faith, bad faith has nothing to do with whether you were accidentally taking rock from somebody else's property, whether you were inadvertently or innocently trespassing upon their property. The distinction between good faith and bad faith is this: a good faith trespasser is a trespasser who honestly believes in the superiority honestly and reasonably believed in the superiority of their
their
title
interest.
as to the property where the rock is being taken from.
To put it in context here, this Romney would have had to have believed that they had a lease on the Armstrong property, but once they know they have no legal right, the fact it's merely an accident does not kick in the good faith exception. That's your argument.
Absolutely, Your Honor, and that is the law. That is absolutely the law. And the reason for it is quite clear. This law grew primarily out of cases on the East Coast that were dealing with coal and also to a certain extent oil reserves.
yes.
And every single one of these cases dealt with a defendant who had a lease in hand or a contract in hand or a deed in hand by which they had a reasonable belief that they had a right to be extracting minerals from the property that they were extracting the minerals from. And these cases grew out of situations in which later on it was discovered that there were problems with the leases, problems with the contracts, or problems with the deed, and that while they honestly and reasonably believed that they had a right to be taking minerals from that property, that ultimately they didn't have a legal right to take it. But nonetheless, they honestly and reasonably relied upon those leases and contracts and deeds to justify taking the minerals from that property. That's where that body of law grows from. That's where the concept of a good faith versus bad faith trespasser comes from. And it's from that context that equitably the courts have said that where an individual has an honest and reasonable belief that the land that he is extracting the minerals from is land to which he has superiority of title, in a situation such as that, and if he later finds out that he was wrong, the landowner should be responsible or should receive not the enhanced value of what was removed from the ground, in other words, the market value, that the landowner should only receive essentially either the royalty, okay, or the net profits, if you will.
What the landowner would have gotten had the landowner taken the trouble to remove the minerals himself or herself.
Exactly.
Honestly and reasonably.
Exactly.
Is that subjective, objective, or both? It sounds like self-defense to me. The defendant has an honest and a reasonable belief that self-defense is required.
I think it's objective because in every single one of the cases, and we're referring, of course, in Kansas, Dexter is the case that brought this into the fold of Kansas jurisprudence, but all of the former cases that were relied upon by Dexter, and every single one of the cases cited in Dexter, every case that was cited within those cases, all related to instances where an individual had an honest and reasonable good faith belief in the superiority of their title by virtue of having in hand a contract or a lease or a deed that on its face looked as though it gave them the right to extract minerals from that property. That's where the distinction grows from. Good faith, bad faith was never about whether you negligently, innocently, stupidly, or malevolently crossed onto somebody else's property. It makes no difference whatsoever.
It's the nature of the tort, too. I mean, it's an intentional tort. And
Correct.
once you've trespassed no matter what.
In the state of Kansas, and of course,
subjective
the state of Kansas has the majority view in that respect.
All right, thank you, counsel.
Thank you, Your Honor.
May it please the court. Opposing counsel's interpretation of good faith, bad faith, the Dexter case, I can't disagree more. What the plaintiffs want this court to do is eliminate the mental intent, take that out completely, automatically put a zero behind the award, and do that in every case, irrespective of what the trespasser's intent was.
Is there an intent requirement for trespass generally?
Your Honor, not in trespass in general, but what
How
we're
about
talking.
conversion? How about the other piece of the hybrid? Is there an intent requirement, a subjective intent requirement?
For conversion, I believe there is. For conversion, I mean, you willfully, knowingly take somebody else's property. And here we're talking about enhanced damages. And when we look at the history of the cases, and opposing counsel referenced a lot of them, but one that I referenced in my brief is a case out of Alaska. And that's an area where you'd expect to see a lot of litigation on mineral rights and the like. And in that case, I think they do a really good job of talking through the reason for enhanced damages. enhance value damages. They're there to punish those folks who willfully, with intent, go in and steal somebody else's resources. It provides a substantial windfall to the plaintiff in the case, as the plaintiffs are seeking here in a situation where they never even timely submitted a request for punitive damages. We're basically going to award substantial punitive damages in a case, irrespective of the mental intent of the party that's alleged to have engaged in the trespass.
Well, what about the Court of Appeals finding that there was mental intent, that there was intent here? That if there's, I mean, they point out that one of your positions is that the plaintiffs should have known that we were taking their rock, and they make the point that if the plaintiffs should have known, so should have a professional mining company should have known. And what's wrong with that logic? What's wrong with that thought?
And Your Honor, of course, that's why we're here.
Especially in light of the fact you have the zero aisle road, and then you have the other road that is actually on the property, and you're south of that mining the rock. It seems pretty clear to me that you had to have known that this was on the property.
In this case, Judge Bednar had the opportunity to hear the witnesses, hear the testimony of Mr. Falk, Mr. Bonnet, Barbara Bromley, who testified. Each and every one of those folks testified since 2003, and even before. Barbara Bromley instructed people, stay off the Armstrong's property. I don't want any more lawsuits. Let's stay off their property, okay? And she instructed that zero aisle to be placed there. She found out that this was occurring based upon a full survey that she commissioned, spent a substantial amount of money, over $70,000, to have this survey performed, because they were at a point where they were starting to run out of rock. And so she had incurred this substantial expense to document exactly where they had been through the course of mining there for decades. She knew that when she engaged this company, Alpha, to conduct this survey, that these folks were going to have to go contact the Armstrongs, that they at that point in time were going to have knowledge that they were engaged in the survey, because they had to get the Armstrongs' permission to get on their property and run cores or get their settings so that they could run the survey. Judge Bednar considered the evidence in the case and made a determination based upon the credibility of the witness that he heard and their testimony, as well as the facts corroborated their testimony that it was not an intentional trespass. And it was not only the fact that Barbara Bromley told her people to stay off, but how did she react when she found out that they were trespassing? She told them to move, stop what you're doing, get off the property immediately. And this isn't because she had just been caught red-handed by the plaintiffs. Plaintiffs didn't know anything about what was going on at this point. And her position, her demand that her employees stop what they were doing immediately was corroborated by the folks from Alpha, from her own employees. In addition to that, Your Honors, we submitted, I believe it was trial exhibit number 18. It was an itemization of the royalties that have been paid over the years. To many, many years, to the Prohaska family, and it's a different Prohaska family. It's the property to the north, okay? And it established that the Prohaska family was paid a royalty on every ton of rock that came out of that mine. Every ton of rock that got sold, the Prohaskas got their, I believe it was...
At 25 cents.
25 cents, right. Which, you know, at the time, that's the fair market value
of the lease value.
Of the lease value, sure.
But they saved 75 cents if the conversion amount was $1 for profit.
The profit was $1. The royalty was 25 cents per ton.
And it helps support the idea that we thought we were taking it off the Prohaska's land. But right. let me ask you this.
Yes, sir.
I understand the argument back to reasonably ascertainable that it was the plaintiff's duty here to make certain that the 1996 court order was not being violated. And why is that? Why shouldn't the Bromley, after being ordered by a court not to encroach on the Armstrong's land, should have been the one with the duty to make certain it's not happening, rather than Armstrong having a duty to catch you.
I think my clients should have stayed off the Armstrong's property. They admitted they should have stayed off the Armstrong's property. When they found out they were on the Armstrong's property at their own expense, they commissioned Alpha Survey to come in and do an evaluation of what got taken and when. And based upon the evidence and the evaluation from Alpha, they made a determination of what had been taken in the last 2 years based upon the ceiling heights. My clients have been held accountable for the trespass. Judgment was awarded in the amount of $10,000 for the Hall Road. The award was provided for the taking of the rock over the 2-year period.
Counsel,
I
my
understand.
impression from my colleague's question was, how can the plaintiffs in this case be required to discover someone has violated the court order when your own client did not discover it until sometime later?
The testimony of their expert was when he walked in there, Mr. Service, he said he knew right away. And the question from the appellate court is, well, if you knew right away, why didn't your people know right away? And based upon the evidence that was presented both in the motion for summary judgment as well as at trial, it's my client's belief that this rock was removed a long time ago. Other than that amount that was taken within the 2 years, it's their belief that this rock was taken most likely in the late 90s, even before this zero aisle was put in. And in fact, it might have even been removed before they had executed a stipulation that occurred, I believe, on the 92 case in the court's order back in 96. At that point in time, the parties were working through a dispute on a lease agreement. What I really wish they'd have done back to resolve that 92 case was to have conducted a new survey, to have gone down there and known just exactly where they were. But what they did is they worked off a survey that was initially put together back in the 80s, and then somebody tried to freehand some kind of an estimate of where they'd gone after that. And so, unfortunately, there's some confusion in terms of where things were going back into the late 90s and then moving on to 2000 and the like. And that's why I have to just impress upon the court, Judge Bednar heard all about all this. He listened to the evidence that was presented to him. He had the opportunity to consider it both on summary judgment. He had the opportunity to hear it at trial. He not only ruled that the claims were limited based upon the statute of limitations, but we haven't talked about the statute of repose. We haven't talked about res judicata, collateral estoppel. Those are also legal basis by which Judge Bednar determined that these claims were limited to the 2-year, to the evidence, to the amounts that the plaintiff stipulated. My clients weren't sitting here trying to just absolutely get away with this. They incurred the expense to conduct a survey, and they came in and stipulated 173,000 tons of rock. And that's a substantial stipulation that they entered into. And as the evidence came in at trial, the defendants or the plaintiffs really had no reliable evidence other than our stipulation in terms of what was taken and when. Mr. Service basically said, I don't know when anything would have been taken.
I've got two questions, counsel.
Yes, Your Honor.
Excuse me.
I'm
These will
sorry.
be the last 2 questions of the evening, so I hope they're really good.
And they're quick. First one, would you agree that you had the burden of proof to show that you were a good faith trespasser? It wasn't Armstrong's duty to show that you were bad faith.
Based on the law, I agree, Your Honor. It is the defendant's burden to prove.
And would you agree that in that presentation of evidence, you made no claim that you had superior legal title to be on that property? Your argument is that it was a mistake.
Our argument is it was a good faith mistake. Yes.
Thank you. Those were excellent questions, by the way, Justice Biles. But why did you save them till the very end? Thank you both
All right.
for your arguments this evening.
Thank you.
The court will take this matter under advisement.